They ruled on the motion for disqualification. We need to take a look at a newly filed motion in the Kouri Richins case and talk about what's going to happen, because it's the end of July. And when we were sitting at the sentencing hearing and they set the restitution hearing for July, it seemed so very far away. And now it's this week. And I don't know if that's going to happen. Why? Because, well, the last thing that the defense filed was a boo-hoo, Your Honor. We think that you were biased. And the judge was like, fine. We'll see if the other court thinks a new judge needs to hear this. So I don't know if we're going to have a restitution hearing on Friday, but we're going to take a look at the state's filing regarding restitution. Statement of relief requested. The state of Utah requests the court issue an order of restitution in the amount of $1,017,018.49 to auto owners insurance and $352,562.61 to True Stage. The defendant's aggravated murder and insurance fraud convictions and the evidence in the record established that the defendant's criminal conduct proximately caused these damages. Here, the defendant's murder conviction establishes her liability as a matter of law, and the evidence in the record clearly establishes causality. But for the defendant murdering Eric Richins, auto owners insurance and True Stage would not have paid on the life insurance policies. Correct. Their payment was not only foreseeable, but also the defendant's motive for murdering Eric Richins. The defendant's insurance fraud proximately caused True Stage's pecuniary damages for the same reasons. Accordingly, an order of restitution in the amount of over $1 million to auto owners insurance and over $350,000 to True Stage is required. Next, conclusion. Pay. That's the conclusion. The court must issue an order of restitution in the amount of $1,017,018.49 to auto owners and $352,562.61 to True Stage. The defense has not responded to this yet. I don't know if we will see the defense respond to this, but when we first heard discussion of restitution in this case, the state was contemplating whether or not, as a part of restitution, they could recover any of the monies paid to the defense team. They've not pursued that here, which leads me to believe that they've evaluated those options and they are not available to them. And they are looking for restitution for the direct victims here. Remember, when we are talking about other damages Kouri Richins caused, there is clearly other economic damages that Kouri Richins caused, not just related to this case, but those are in the separate fraud case. There's 25, 26 causes of action in that case. So when we're looking at like literally you stole Chelsea Barney's house, like, which always makes me think of early days Real Housewives of Beverly Hills.
Everything I've done for you, I'm always there for you.
Everything you've done for me?
Yeah, everything I've done for you.
You stole my goddamn house!
That is going to be a restitution order in that case, because the restitution order in this case is more directly tied to the murder case. And remember, the court pulled out some of the other financial crimes. So her other case, her financial crimes case, is still pending. And yes, Chelsea Barney and other victims can still get restitution there. This also doesn't undermine the lawsuits that are going on with the estate, because if restitution is paid here, I could imagine a situation where restitution gets paid in some amount to auto owners insurance or gets paid in some amount to True Stage. And then the estate says, hey, auto owners, hey, True Stage, those are monies that should have been paid to the estate. We need you to pay those back to the estate, because this is also overlapping where the estate is going after some of these funds as well, because these are monies that should never have gone to Kouri Richins. They should have gone into Eric Richins' trust. I can imagine Kouri doing anything legal, illegal to try to move money around so it doesn't end up in the trust. And the fucked part of that for me is that the trust benefits her kids. We double clicked the docket and damn, I'm so glad we did. what I was just saying is that we were going to check and see if the restitution hearing for Kouri was still on calendar. And the restitution hearing for Kouri Richins is still on calendar. And I said that the only way that that could go forward is if the supervising judges had ruled on the request for disqualification. And then when I clicked back to the docket has a ruling. The title of this motion is Order Denying Request for Disqualification. Well, spoilers. Filed July 29th, 2026 at 12:44:36 p.m. I can't wait to see what they say. So let's get into it, shall we? This is from the reviewing supervising judge. Before this court for decision is a request to disqualify Judge Mrazek. Pursuant to Rule 29B2A of the Utah Rules of Criminal Procedure, the judge against whom a motion to disqualify is, quote, directed shall, without further hearing, enter an order granting the motion or certifying the motion and affidavit to a reviewing judge. Judge M did not grant the motion, but instead, on July 1st, 2026, he certified the request to me as the reviewing judge as part of my responsibilities as associate presiding judge for the 3rd District Court. See the certification, docket 1787. As pointed out by Judge Mrazek in his certification, the request for disqualification is contained on pages 10 and 11 of defendant's motion for new trial. Bold strategy. The court has reviewed the materials submitted by defendant in support of the disqualification request, including Exhibit A. The court awaited receipt of Exhibit A to render this ruling. Exhibit A was provided to this court on July 17th. No. The motion was filed and Exhibit A was sealed, but the motion for new trial was filed June 30th. So June 30th, the motion was filed and they waited until July 17th to receive Exhibit A. The court enters its ruling as follows. Rule 29, procedural requirements. We clocked this immediately. The second we read the rule, we clocked it. Rule 29B of the Utah Rules of Criminal Procedure sets forth the following procedural requirements for a request to disqualify. The motion shall means must. Shall be accompanied by a certificate that the motion is filed in good faith and shall be supported by an affidavit stating facts sufficient to show bias or prejudice or conflict of interest. We clocked this immediately. We pulled up the rule on stream when we went through this motion and we were like, well, they might yeet it on procedural grounds. Or they might eat it on procedural grounds and say, even if those had been included, we don't find it sufficient. The court goes on to say, the disqualification request is not accompanied by a certification of good faith, nor is it supported by an affidavit or unsworn declaration. Thus, it is procedurally deficient and is denied on that basis. A certification of good faith and a sworn affidavit are large procedural requirements that the defense fundamentally failed to meet because they didn't file a proper motion. So they spent almost 14 pages panning a judge and then saying, you need to recuse yourself, and then failing to properly file a motion to disqualify. Ouch. Rule 29 requires a request to disqualify to be filed no later than 21 days after the last of the following. B1, assignment of the action or hearing to the judge. B1B2, appearance of the party or the party's attorney. Or B1B3, the date on which the moving party learns or with the exercise of reasonable diligence should have learned of the grounds upon which the motion is based. We clocked that too. And we said in this scenario, we're going to end up in B1, B3, which is when do they believe the judge was exhibiting bias? And they went through the different trial examples. Well, that means you have 21 days from the example of bias that you are citing to file the motion to disqualify. But they asked for extension after extension on their motion for new trial and then spent literally like 11 out of 14 pages arguing that the new trial should be granted based on the judge's bias, but they never filed a motion to disqualify the judge. And it would have been needed as untimely. And their next header is, even if it's not untimely, let's look at the grounds. With respect to the instant request, the last applicable date would fall under subsection 3. The date defendant knew or should have known of the grounds upon which the motion is based. The grounds asserted for disqualification is the conduct of Judge Mrazek during trial. The last day of trial was March 16th, 2026. Thus, the motion filed on June 30th, 2026 was filed more than 21 days after defendant learned of the grounds upon which this motion is based. And it is untimely. Untimely! 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 The motion is denied for this reason as well. Third, the grounds for disqualification, which means the judge has decided that even if the procedural grounds were there, I'm going to tell you what. Even if, this is the arguendo, even if the motion met the procedural requirements of Rule 29 and was timely filed, it fails to state facts sufficient to show the level of bias, prejudice, or conflict of interest that Judge M required to warrant a disqualification. Defendant argues, under the case of Boo versus Who, that Judge Mrazek should be disqualified from ruling on her motion for new trial because Judge Mrazek is biased and because the motion is based in part on his alleged bias. Motion at page 11. Judges are presumed to be qualified, and a party alleging bias on the part of the judge has the burden of demonstrating that the judge is not qualified. And then they cite the case law. The bias or prejudice must usually stem from an extrajudicial source, not from occurrences in the proceedings before the judge. It is a difficult standard. A judge's behavior toward a party during court proceedings must be extreme to warrant a finding of prejudice under Rule 29. The Utah Court of Appeals has held disqualification is warranted, quote, only when it appeared that, apart from the judge's analysis of the issues of fact or law, he had such a bias in favor of one party or prejudice against the other that he could not fairly and impartially determine the issues. That is, the affidavit must allege facts indicating that, quote, the judge's behavior towards a party during proceedings was extreme and reflected a deep-seated antagonism toward the party requesting recusal. And then it states the case law for that. Defendant alleges that Judge Mrazek was impatient, critical, hostile, disparaging, and condescending towards defense counsel, and in contrast was friendly and helpful towards the prosecution. The court finds the video excerpts of trial provided by defendant on Exhibit A and the trial transcript references in the motion do not demonstrate the level of extreme behavior or conduct reflecting a deep-seated antagonism towards the defense, nor favoritism towards the prosecution to warrant disqualification. Even if Judge Mrazek's conduct could be considered as showing anger or frustration with defense counsel, that is not grounds for disqualification. The court finds and concludes Judge Mrazek's alleged conduct falls well short of, quote, revealing such a high degree of favoritism or antagonism as to make fair judgment impossible. For all the foregoing reasons, the court concludes defendant has not demonstrated grounds to disqualify Judge Mrazek, and her request is denied. This is the order of the court. Who is going to be ruling on the motion for new trial? Judge M. It's going to be Judge M. It's going to be Judge M. The court has denied the supposed motion for disqualification. And when the hearing gets set for the motion for new trial, we will be there. And it looks like game on for Friday then, unless between now and then the defense files a motion to continue to figure out WTF is next. So that's going to be awkward and interesting. There are things this defense team has done that I have never seen before. They made what seemed like very personal impact statements for Kouri. They were not attorney argument. They seemed like personal character impact statements, which was wild to watch. But then the strategy they chose with the motion for new trial seems so odd, to spend the majority of your motion just trying to burn it all down is a crazy strategy. The defense's, you should disqualify yourself, Your Honor, did not work. And the reviewing court said, hey, we didn't even get the thumb drive of the video until July 17th. This motion was filed on June 30th. And less than 10 days later, we get a ruling from the court just in time for those hearings on Friday to now go forward, because Judge M had said, I will take no further action in this case until the motion to disqualify is ruled on. So what happens now? Well, we have to wait till September for Bloodworth to respond to the motion for new trial that's going to be heard in front of Judge M. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.